She was called a thief. The security camera caught someone else. She sued for $4,200. Her former employer called her a thief. The surveillance footage would decide who was lying, and it wasn't who anyone expected. When the plaintiff walked into that leasing office on a Tuesday morning in early March, she believed she was picking up the remainder of her security deposit. What she got instead was a bill for $4,200 in damages, a letter accusing her of destroying company property, and the beginning of a 14-month legal battle that would end careers, expose secrets, and force a courtroom full of strangers to ask one uncomfortable question: what do we do when the powerful rewrite history? The plaintiff had been a co-founder of a mid-sized marketing consultancy, a firm she helped build from a borrowed desk in her co-founder's spare bedroom into a 12-person operation with a downtown office lease. The arrangement was unconventional from the start. Because the company had no credit history in its early days, the plaintiff had personally guaranteed the office lease and paid the $4,200 security deposit out of her own savings. That was 4 years before the lawsuit. By the time she departed the company following a bitter ownership dispute, the firm was profitable. Her name had been quietly removed from the founding documents, and the office deposit was still hers, legally in writing, per the original lease agreement. Her former co-founder, now the defendant and sole named executive of the company, told a different story. When the plaintiff's name was removed from the lease renewal 18 months prior, the defendant argued so was her claim to the deposit. He produced a lease amendment, signed, dated, transferring deposit rights to the business entity. He presented a damage assessment from a commercial property inspector: gouged hardwood floors, a cracked interior window, scuff marks across 3 walls. The total repair estimate came to $4,850. He wasn't suing her, he was simply explaining, he said, why she wasn't getting her money back. The plaintiff sued for the return of her $4,000 in small claims court, which was later elevated to civil court when the defendant counterclaimed for the full $4,850 in damages. Her position was straightforward. The damage didn't exist when she left the company. The lease amendment, she alleged, had been backdated. She had never signed it. That was her signature, the defendant insisted. She signed it at a routine lease review meeting 14 months ago. She didn't recall any such meeting. Neither, it turned out, did her calendar. Her attorney submitted a forensic document analysis of the lease amendment. The examiner noted inconsistencies in the ink saturation consistent with accelerated aging, a technique sometimes used to make new documents appear older. It was suggestive, but not conclusive. The defendant's attorney countered that the plaintiff's own expert admitted a margin of error. The courtroom was balanced on a knife's edge. Then the building's property management company was subpoenaed. They handed over something neither side had anticipated: continuous lobby and hallway surveillance footage archived automatically to an off-site server. Not just footage from the plaintiff's move-out date, footage from 14 months prior, the date the defendant claimed the lease amendment was signed at a routine meeting. The plaintiff was not in the building that day. The footage showed the defendant entering alone, meeting with the property manager for 11 minutes, and departing. No co-founder, no joint meeting. The footage also showed the office hallway on the plaintiff's final day in the building: intact floors, no visible damage, a handshake with the office manager at the door. The damage, the judge concluded, had been fabricated. The lease amendment had been signed without the plaintiff's knowledge or presence. The defendant had constructed a paper trail designed to absorb a $4,200 liability and shift blame onto a woman he had already worked to erase from the company's history. The judge ruled in favor of the plaintiff. She was awarded the full $4,200 security deposit, plus full $800 in legal fees. The counterclaim was dismissed. The judge stopped short of referring the matter for criminal fraud investigation, but noted in her written ruling that the evidence of document manipulation was, in her words, deeply troubling and not to be minimized. The defendant appealed. The appeal was denied 4 months later. The plaintiff used the settlement to help cover costs she'd already incurred fighting a separate dispute over her equity stake, a battle still ongoing at the time of this writing. The defendant's company lost 2 clients in the months following the verdict when the case received local business press coverage. The office manager who shook the plaintiff's hand on her last day in the building gave a voluntary deposition confirming the floors were undamaged. She no longer works for the defendant. Surveillance footage doesn't lie. But here's what this case left unresolved. If that server had been wiped on a routine cycle, as it nearly was, just 2 weeks before the subpoena, Would we have believed the woman with no evidence over the man with forged documents? And how many times has that question already been answered the wrong way?